It's a unusually rainy day in Delhi, and it's been continuing for some days. And I'm grateful for the ones who can join us in person. For the ones who are streaming, catching the live stream online, thank you so much as well. And today we'll be organizing a wider discussion at IIC to mark the Diamond Jubilee on Digital Governance Cluster Group on a discussion titled as Data, New Oil and Privacy Rights. Here I'm joined by a very eminent panel, people who have collaborated with each other. They have been part of several public interventions and been greatly influential in the formation of various policies regarding digital governance in India. Firstly, it has Rama Vedashree, who's the CEO of the Data Security Council of India. Seated beside me is Nikhil Pahwa, who's the founder of MediaNama, very well-known commentator on tech policy issues as well. There's Sreenidhi Srinivasan, who's a partner in Ikigai law and specializes with respect to a lot of private advisory as well as policy advice regarding technology matters. There's Mansi Kedia, who's an economist and a research fellow at ICRIER. And we have Sinha, who's a senior fellow at Mozilla. And today, for this discussion, initially I will be opening up remarks for 2 to 3 minutes, and I'll request all panelists to switch on their mics. That's essential for the audio to be captured in the live stream. And I'll be referring to certain things they have written on data protection and privacy over the years and asking them to expand on it. So firstly, just setting some context. In 2017, the Supreme Court of India in the month of August rested all controversy regarding the status of the fundamental right to privacy. It linked it to every fundamental right. And thereafter, there was increased activity around the formation of a personal data protection bill. This bill has been withdrawn in the last session of Parliament, and today the field again looks open. Going forward, I would first like Nikhil to come in and comment on this based on his earlier disappointment which he had expressed. Writing in the Times of India, he had about 2 years ago stated, in reference to a data breach, quote, "No one was held liable, there was no data protection law, no data protection authority, no criminal prosecution was recommended. Around that time, the Indian government was instead arguing in the Supreme Court that privacy isn't a fundamental right under the Indian Constitution." End of quote. Nikhil, as we look ahead, has this stance changed, and what can we hope for?
Thanks, Apar. It's an honor and a privilege to be here to speak at the Diamond Jubilee celebrations of the IIC. I think before we get to whether I'm disappointed or not, we need to understand why is privacy important and why is data important and why are we in this mess. We are in the mess that we are in with privacy globally, and there's a global market failure in privacy because of advertising. Some of you may recall that there's the old saying in advertising that 50% of my advertising spends are going waste. The problem is I don't know which 50%. And digital advertising, through tracking, profiling of individuals, has sought to address that gap to reduce the wastage in advertising so that they're able to target people when in a manner that they're able to profile what people want when they want it, identify intent, identify what their interests are, and target them with advertising to get them to buy things. That has led to profiling, and expectedly it's led to manipulation, to the extent that we have manipulation of democracies using the same skills that advertisers have used to sell products online. And so at the heart of this mess is data, and data on us, and essentially we are data in bits and bytes. Every little bit of our activities is tracked. When you're reading an article, how much time you spend reading that article, how much you scroll reading it, what you click on, what you do your mouse over on, all of this information is tracked, you're profiled, and it's used to sell you stuff. But uh, governments have a different view on it, and that's where privacy becomes a problem for them, because government view data as the new oil. They view it as the fuel for the fourth industrial revolution, for the growth of an economy. And that's why when you look at multiple versions of the data protection bill that have come out, they've pitted two goals. One is for protecting citizens' rights to privacy, and the other is to use data to enhance the economy. And a privacy bill can't have two goals. I mean, effectively, it should be protecting our rights. So, when a government views data as the new oil, how does it behave? It tries to generate as much of it as possible. It tries to link to profile citizens as much as possible. It tries to protect that data from foreign usage, from foreign interference, because it's a national security concern then. And it tries to control the platforms that lead to the generation of this data. So effectively, what it's also trying to do at one level is prevent what it calls digital colonization of the transport of data out of the country. And so these two competing interests of both privacy and economic growth, and national security linked to that economic growth, is what we're dealing with. And in that sense, when you have a law that protects privacy, when you have a law that prevents the government perhaps from taking as much data as it can and giving it to startups to grow, or using it for its own purposes, when you have a law that prevents political parties from using the same tools that are there for advertising to manipulate elections, when you have a law that essentially prevents law enforcement agencies from getting into your phones from a security perspective, governments don't want that. So if there's a delay in the data protection bill, why should we be surprised? If the government goes to court and argues that privacy isn't a fundamental right because it wants to build a profiling and data generation system under Aadhaar, why should we be surprised? So I'm not surprised that this data protection bill is delayed. I wouldn't be surprised if it gets delayed even further, or if it protects the government's interests instead of protecting the citizens' interests. I wouldn't be surprised.
Thank you, Nikhil. And at the same point in time, the economic value of data is sometimes underemphasized when we focus on the criticism, and which brings me to my own usage of digital technologies. I'm a total dependence on them sometimes. Here, the free flows of data quite often have been very important, which provide us the kind of services which are necessary, right? But at the same point in time, and I'll turn towards Rama for this, given that she's been a part of the Vedashree Krishna committee, she's written a separate note from which I'll read out and then set context for this. In the separate note, which was submitted to the Vedashree Krishna committee on data protection, she had written that first, the draft bill in its present form places restriction on cross-border flow of personal data. This approach is not only regressive but against the fundamental tenets of our liberal economy. Moreover, the inclusion of such restrictions in a bill that should focus primarily on empowering Indians with rights and remedies to uphold their right to privacy seems out of place. Rama, this comment which you have written sometimes seems opposed to the data localization mandates, which hard localization mandates, or the data sovereignty arguments which are sometimes made. Is the true value, economic value of innovation and harnessing the innovation and new products and services which come through the use of personal data at risk through data localization mandates? And what's been your experience speaking from the Data Security Council of India, in which there are several industry members, primarily from Indian companies?
Thank you, Apar. First of all, a warm welcome to all members of IIC to our panel. It's a privilege to be here along with very young, bright minds. So first, I mean, when you look at the economic value of data, prior to that, I think I strongly believe that we need a robust privacy a law plus an enforcement framework, because I think Supreme Court recognizing privacy as a fundamental right was a pioneering milestone. And as more and more digitization is happening, when you look at any business, small, medium, to the very large regulated enterprises, when they call themselves now a technology-led enterprise or a digital enterprise, I would say they're equally a data enterprise. Almost everything they do hinges on their ability to analyze data and build new targeted services, very hyper specialized, personalized services to their consumers. Particularly any entity, whether it's public sector or private sector, which is in the business of business to consumer or government to citizen, I think they're hinging a lot on what they can do with the data, right, of the consumers or of citizens. So I would first say that before we can look at the economic value of data, that privacy protection, particularly of sensitive personal data, is very important. And in the absence of a legislative framework and a very good enforcement mechanism, it's going to be very difficult to achieve that goal. In terms of economic value of data, I think that was my dissent note, which was Justice Sri Krishna, the chairperson of the committee, was kind enough to accept my dissent note and put it in the report, was that I still believe that cross-border data flows are extremely important. Even when there is privacy regulations, very different regulations coming up in many countries, while I also strongly argue for harmonization of many of these privacy legislations that are coming up. Cross-border data flows are very important, particularly coming from the industry from which DSA comes from, the technology industry. Whenever they build a product or a service offering, they're not building it for a market. Even startups which are building products and solutions, it's not like they're building it for a market. They're building it for global markets and of course the India market. So it's extremely important that when they build a product, they should be able to leverage the principles of cross-border data flows and no hard localization, right? Maybe there may be some sets of data which are very critical for national security, and we may come up with this. That means a data classification framework which is able to do that, rather than a blanket thing that any data which can be declared as critical down the line, where there is a lot of uncertainty. So even when you're building a service offering, a digital service offering, or a digital service or a product, the uncertainty of what is expected to be localized, even if we go down the path of localizing something, is just impossible for you to implement a robust privacy program, because you have to tweak your systems. So I still believe that there needs to be cross-border data flows, because when you look at in the digital side, most services, particularly post-pandemic, everybody is moving a lot of critical solutions onto public cloud. I've come from data security, where we very closely scan the cybersecurity product ecosystem. In the last 2 years, the number of cybersecurity products which are now cloud native products, that means consumers are customers are consuming not just vanilla business services, but they're consuming cybersecurity services and products of the cloud. Our tech industry is managing security operations centers for multiple global customers sitting in one of the cities in India through the cloud. So even security services are being offered through the cloud. So it's extremely important that we look at the way actually digitization happens across the world, and when a provider sitting in any part of the world, and of course we are now the largest growing digital hub, we are a $220 billion industry in India, and when we are servicing so many customers across various countries, and lot of them are also data analytics companies which are analyzing the global data of global customers, a bank in the US or a health or pharma company of a EU. So we can't be putting those kind of constraints, but that doesn't mean that we should not have a strong framework. There should be some predictability and certainty on what those laws are and what those regulations are, so that industry can gear up for. I'm sure when the final law comes, industry will gear up for. The tech industry has geared up for the EU GDPR, but we should not put those constraining things. We should have very clear privacy principles. Nikhil talked about, the way data can be, monetized beyond limits. So the worldwide regulators are dealing with this problem of not only government surveillance but commercial surveillance, right? Where any consumer's information, building a 360-degree profile, or the same thing can happen for a citizen of a resident of a country. So we need to thwart these things of surveillance, whether it's from a private sector entity or from a public sector entity, and even organizations like the FTC. I'm sure a lot of us keep hearing about the congressional hearings in the US. So it is both about commercial surveillance, but also potential for government or a public sector agency in any country, not just in India, to be able to use digital technologies and the data for surveillance, and that I think needs to be thwarted.
Thank you so much, Rama, for those excellent initial remarks. And Sreenidhi, I'll come to you now, and I have the pleasure of holding in my hand a paper which has been written at the ORF and Ikigai on India's proposed data protection law and the India-US executive agreement under the Cloud Act. And it seems very complex, but I think it's at the root of why the government also wants, quite often beyond the economic aspect, which explains the security complaint which we hear quite often, that a large number of Indian users are on foreign platforms and we can't get the user data as easily. You conclude by saying, finally existing and proposed local storage requirements in India are likely to pose obstacles to an executive agreement, I add here, between India and the United States on the Cloud Act. However, given that the proposed law to an extent requires mirroring rather than a hardline view on exclusive data storage, there may be still room for negotiation. Now, Sreenidhi, for a general audience, if you can explain what's the Cloud Act, why is this important for an agreement for us to reach, and why data localization, actually something which we think by storing the data here makes things easier, may actually end up hurting us, if I've got that correctly.
Sure, thanks so much, Apar. Hi everyone, it's lovely to be here. So I'll probably set the context a little bit, just explaining the problem that we were trying to address in this paper, and what the Cloud Act, what the US Cloud Act is. So I think we'd envision a scenario where there is an entirely Indian crime. The victim is Indian, the perpetrator is Indian, it's taken place in India. The only sort of connection to US or sort of any foreign server is the fact that the email that, say, the perpetrator had used or sent out is belongs to a US service provider or a foreign service provider. So when Indian police wants to investigate and get access to that email, and they go to the US service provider, the answer that they often get is that US law bars us from sharing this data with you, and that poses a challenge to Indian police. And there's a sort of a bilateral mechanism, a treaty mechanism, which then Indian police must sort of, make a requisition, make a request, through which, and that process takes anywhere between, say, 10 months to 3 years to materialize. So this was the very sort of narrow specific problem that we were looking at, and a different aspect of cross-border data sharing in the context of law enforcement access to data. Now, what this US Cloud Act does is it sort of provides for an alternative mechanism. It says that if India and the US were to enter into something called an executive agreement, Indian police or Indian law enforcement agencies would be directly able to go to the US service provider and say that we would request access to this data because this is required for a serious crime that has taken place in India. Of course, there are some guardrails around it, some checks and balances. Before that, the US government has to, vet whether Indian law, whether the request is kosher under what the Cloud Act requires. That's essentially, I know this is a bit sort of hyper specific and narrow, but that's sort of like the lay of the land here. And the challenge that we also faced in sort of identifying and kind of narrowing down on the research and what might be possible solutions here is for the government, often localization has emerged as a viable sort of alternative for them to think of. Let's ask US service providers or other foreign service providers to store certain kinds of data in India. But we found in our experience, working with several tech companies, that's often it gives rise to technical inefficiencies, because essentially you're thinking of data like you're thinking of people traveling from point A to point B, but data might not actually work or be processed similarly. It's you can't really think of one piece of data traveling from India to the US. It's rather, I don't know how to explain it, but like pinging in some way. So whether those borders really work in the context of data and cost efficiencies as well, rather than relying entirely on what is most efficient for the business, the business then is kind of bound by the law saying that these are the guardrails, this is physically where you must store data. So we were also trying to think of alternatives to that, and exploring an agreement of this sort, some kind of a bilateral arrangement between India and the US seemed like a potential option. That's sort of the context for the research here.
Thank you so much, Sreenidhi, for setting out that context. I'd like to also step back now. We've heard from Nikhil, who's told us about how the data protection law as it was framed and there were delays may have benefited the government instead of the individual's fundamental right to privacy. We've heard from Rama, who's also brought in an interesting private sector perspective on how cross-border data flows are essential in the reality of the experience of digital services today. And from Sreenidhi, who's explained us a little bit about the US Cloud Act. The objective and how I've structured this panel also is to encourage this diversity, because data does not mean one thing. And the range of issues today presented are fairly broad. And at this point, I think it's great to just bring in Mansi and do some service to the title of this panel, which is New Oil and Data. For she's written an excellent paper at ICRIER, co-authored it, and she states that the role of data in the economy and society, especially in Indian society, and she explains it very well by saying that according to the Austrian thinker Friedrich Hayek, the central economic question facing any society is how to best allocate scarce resources to their more efficient use. In the context of the paper, it means addressing the fundamental problem of how to best utilize data and knowledge for social and economic gains. And here she uses a very interesting example. I continue to quote. Indian society, for one, has witnessed path-breaking transformations owing to the diffusion of mobile internet and the applications of big data analytics. One of the most interesting examples is that of the matchmaking industry, where mobile connectivity has enabled scores of people, even from rural areas, to access a vast database of potential suitors. So, Mansi, is data just the new oil, or does it structure social relations very differently based on your research and work?
Thank you, Apar, and thank you, everyone. It's absolutely delightful to be here. So, I'm taking a cue from what Apar said, and in our research, and I think, let me step back. As a policy researcher, I think one big lesson that I've learned is that policy is always about trade-offs. And as you have seen through the course of the discussion, there is this constant for the lack of a better word, like a conflict or cross purposes at which you have privacy, competition, economic gains, and social value. And I think the solution lies somewhere in the middle, where we are able to pick and choose and arrive at what is most meaningful. And this obviously is contextualized to a country or to a society or to a community. But what lies at I think the reality is already established that we are hyper dependent on data, and that going forward, as we're looking at digitization, there's no running away from this problem. So we can't just wish it away and say that let's not digitize. That's not an option. We are already on that path. So there's no turning back, and therefore the next best thing to do is to think about how we can maximize those gains. And like Apar said, there are so many manifestations that we see, so much social upliftment that happens when you listen to these really beautiful anecdotes about how data and digitization is helping people across the world, and then you juxtapose it to how, not putting them, not trying to show them in bad light, but the problem that dominant firms bring to society and economic value. So there is this contrast and there is this problem. I think there's a good news, and I picked up this word from one of the seminars I went to, was intersectionality. And this person was talking about how privacy, in some sense, has become intersectional with a lot of the other economic regulations and problems that we are dealing with. So I think some of the really good things that came through some research that we did is how, and that report hopefully will be out soon, is how privacy has actually become a competitive advantage for some firms. In a survey we did, and there were people who put value on companies who valued privacy. So in that sense, there's a competitive edge for a company that is placing value on privacy. Similarly, for how competition authorities are now viewing privacy as very core to some of the decision making they're doing. We've never heard in the past where an M&A agreement was being seen through the lens of what harm it could have on privacy. There is the sustainability guys who are looking at, is this company investing in the environment? All the investors who look at these ESG norms are also looking at privacy enhancing techniques. So I think privacy in that sense has become much broader than just looking at it's expanded what fundamental really means to us, and that is helping us. And I think why is because at least across a few countries we find an amalgamation of minds and we find an amalgamation of values where people are able to think of it as a collective problem and not necessarily as a privacy authority, an antitrust authority, and a consumer protection authority. Unfortunately, that still hasn't happened in India. So I would, I'm going to differ a little bit from what Nikhil said, that the draft of the privacy bill lay emphasis on the economic aspect. I think it is important that they did, but at the same time, we don't want a data governance bill to only talk about the economic value. We need to find a way to. It's not easy, like it's a complex problem. I know it's easier said than done, that we need to find the balance, but at least that's the right approach. And I find the work on, for any of you who might be interested, I find the work on that Singapore has done on their data portability extremely useful as a model for how to think about these problems, how they've approached co-regulation, how they have approached talking to stakeholders, that even if we were to force you to give your data, how would you put a value on that data? So you're not saying that we need to share data because we want innovation and there's data dominance and you guys have hoarded all the data. No, you want to share your data, but we're going to give you a value to the data. How will you value that data? So there is discussion where everyone feels like they can be a part of the problem, and there is this drive to solve it collectively. And I'm driving towards a bit of philosophy here in terms of how policy making should really happen, but I feel like there's more hope in terms of how we are approaching policy making going forward. I think there is a recognition that we cannot work in silos when it comes to data, because data and digitization is more horizontal. We are not a telecom industry anymore. We are not IT services anymore. Digitization is pretty much horizontal, and I think the way to deal with it will also be to look at it across institutions in India, as is already happening in the rest of the world. I'll stop here.
That's excellent, Mansi. For that sets up where I bring in Amber. Amber wrote such a useful paper, which is almost a stakeholder mapping, if I may be permitted to classify it as that, in EPW Engage, titled as "The Politics of India's Data Protection Ecosystem." And this is what he noted actually, and this just picks up from what Nikhil started, and it's just been going down. And I'll just quote it because it just touches upon that now. Quote, "What we witness is a lack of convergence between the position of personal data being considered as a matter of right under the draft law and the Puttaswamy judgment on the right to privacy in 2017, and that of data as an economic asset to be exploited for national gains under the various policy documents mentioned in this essay. A resolution of these two contrasting positions is essential for a coherent regulation of personal data processing." Now, Amber, the personal data protection bill, which then went to, subsequent to this paper, I would imagine, went to the Joint Parliamentary Committee, and then became the data protection bill, is no longer on the table, right? And what would you term it as a resolution towards? And I know I'm being provocative, but what is this a resolution towards? Data as an asset or privacy by itself? As much as I know the answer, maybe. And what can we hope for in case we look at the ministerial statements which are coming, and that has been fairly public, and that's to our benefit, the government is speaking its mind, that it intends to come out with a comprehensive digital regulation, even looking at gatekeeper power, not just from the prism of data protection.
Thanks, Apar. It's everybody has said so, but I'll echo the sentiment that it's a privilege to be here, along with this very, very esteemed panel. I mean, when Mansi was speaking, I was actually feeling a little bit envious because I actually share Nikhil's despondence completely on this issue, and that's not a good place to be when you're part of these policy discussions. I mean, I'll take a step back to try to answer your question, Apar. So the political process towards creating a data protection law in India is more than a decade old, right? So first privacy bill that we saw emerging from what then was the Department of Personnel was back in 2011. They had another bill in 2014. There was the AP Shah-led commission which produced a report in 2012. Then we've had some civil society drafts from the organization that I used to work at, Center for Internet and Society, and the organization that Apar leads, which is Internet Freedom Foundation. We've had, at least to my off the top of my head, 4 different private member bills over the last few years. So there have been various legislative attempts, or even if you were to disregard the civil society processes as illegitimate or not really formal in any way, there have been various legislative attempts, but it became serious in terms of some kind of commitment from the political elite only with the Puttaswamy judgment, right? And that's also ironic because the commitment to create a data protection law was in the furtherance of the argument that we don't need a fundamental right to privacy because we are going to protect privacy through a data protection law and treat it not as a constitutional right but as a consumer right, so to speak. So the difference of the last sort of 5 years has been that political commitment has not, there is a political commitment to some form of data protection law, and that because it was said in front of the Supreme Court has not wavered, and I think that is perhaps the only cause of celebration in terms of the progression of that discourse that we see. The problem that I think we started with also is that there are a number of things that is wrong with the internet today, and we somehow think that the data protection law will solve all of them. So this begins with, I think, the very first draft, where along with the protection of privacy, a fair and free and fair digital economy was identified as a primary objective of the law. And then that got expanded to interests and security of the state and the need for norms for social media intermediaries in the next law. And by the third version, the number of objectives has expanded to about 6 or 7. So I think that is the fundamental problem here. So it's completely legitimate for the state to come up with policy objectives for any law, and these are political problems. These are serious problems that we face that need to be solved. But the thing that I find troubling here is that Puttaswamy casts privacy very, very clearly as both a negative and a positive right, which means that your fundamental right to privacy not only gives you protection from intrusion from the state, which is its primary purpose, but it also casts a positive duty on the state to protect your privacy from private sector. So and that translates into having a data protection law, right? So there is a clear mandate in effect that comes towards creating this law, and what we've seen happen through the course of multiple bills is that mandate has gotten extremely muddled. And at this point, it's not very clear what this law is supposed to do. It's even more disheartening to see, news reports which talk about now we're going to have some kind of Digital India Act, which will include all manner of things, and privacy is going to be a part of that. So that, given how we've seen the last few drafts proceed, it worries me even more. Or maybe we're going to have 4 or 5 different acts which will look at this issue. So I think that is where it is important to understand this political process. But I think what we fail to remember often is that there is a political economy of interests around this, right? So there is the state interest in terms of access to data. There is the domestic industry, or part of the domestic industry, interest in having data localization. There is sort of obviously a lot of lobbying by big tech companies. There's lobbying by the US State Department and their representatives in India. All of it sort of plays into it. But I think when that mandate comes from a fundamental right, as part of this process, and I think that was the responsibility that you expected the JPC to discharge, which it hasn't, was to protect this political process from getting completely hijacked by other politically economic interests here. So I think that's what we've seen happen. And I think when I wrote the EPW paper that you mentioned, things actually look much more hopeful than they do right now.
So Nikhil, since you started despondence, I would now turn to you for some alarm, and because it may shock us into a very different sentiment. Nikhil, I've noticed over some period of time that especially members of civil society, you also have stated that our approach towards regulation seems to be much more influenced contemporaneously by China and other authoritarian impulses rather than by Europe or the United States. While officially public documents say that we need to create our own path. And I'll quote you from a recent from a paper, like an interview, and that notes your contribution during the net neutrality campaign, which was called SaveTheInternet.in, and it accurately states the man who rallied against India against Facebook worries digital nationalism has gone too far. And I bring this in also because the Save the Internet was in some way a nationalistic campaign. Startups, in the true sense, in the dictionary definition of the word, in the sense that we were saying that the free and open internet is what India needs, right? But today, has it gone too far? As you state, I think there is a split we are accelerating toward. Just like the Chinese internet and the Russian internet that are very distinct from the rest of the world, I think we are going to see more of these blocks getting created, where jurisdictions are going to assert their sovereignty in the same manner the EU is doing it when it comes to privacy. Is this really wrong? And what is the potential impact on users, much more tangibly for a general audience, if the internet in the Indian experience is different from the global internet itself?
So, Apar, you and I have grown up with the global internet, right? It's the internet that we love. We've made friends across the globe. People we've never met sometimes, right? Had conversations with people we don't know and they don't know us, and we're all anonymous. And there is a beauty to those conversations, that learning, that growing up with, finding new thoughts that allows us to evolve. And so I'm a believer in internationalism and globalism, and I think the internet has brought more power to globalism than any other invention so far. And it's also been enabled by a startup ecosystem that has used the global economies of scale to grow and build things that people don't even know where it comes from. Like, I didn't know for the longest time that Skype, I believe, came out of Israel, and so you don't know where it's coming from. You just see an app, you see a service, you use it. And what happens is that when you talk about, for example, data localization, right? You don't know where that service is hosted. Sometimes the founders of those businesses themselves don't know which country that data is stored in. And because of the scale of the internet, that the costs of building something new that is wonderful and innovative and iterative, because there's this concept that's being talked about over the last 4 or 5 years called blitz scaling, which is how most startups have started scaling their business. They build a minimum viable product, they collect data, they see how users are actually using the product and keep iterating. What works gets built on, what doesn't gets discarded. So that ability to iterate and innovate is what we have, and that's what the global internet brings. The moment you start slicing up the internet into pieces, into in where someone who builds an app in Mexico will have to spend an extra amount of money to localize the data in India, they might choose not to service India as a market, which means I, as a user of the internet, will not get access to it. I mean, look at it, right? People in China can't use WhatsApp. People in Dubai can't use WhatsApp calling. We have that slicing that's taking place. There is the US version of the internet, there is the EU version of the internet, there is the Chinese version. And the more I look at how the Indian policy system, ecosystem is evolving, I can see that we have China envy. We like the centralization that China has in terms of power. If you look at systems that are being pushed, like UPI has been fantastic for payments, but you can also see a push against MasterCard and Visa at the same time, so as to make sure that that UPI becomes a monopoly. Governments like centralization because they can control through not just people but also the economy through those centralized platforms. You're seeing that built for the e-commerce ecosystem with ONDC. You're seeing that with Health Stack for the health ecosystem. So you've seen that in taxation with GST, with the centralization. I'm saying what you're seeing,
Nikhil, if you may,
more and more, what you're seeing more
on
and
this
more.
only, I would like you to expand.
Yeah.
Because I may be partial towards this side of the argument, and I'm disclosing my bias, but quite often when I'm in a policy dialogue, I'm also told that these are digital public goods and enable, for instance, WhatsApp's interoperability with any other system because it's a closed system within WhatsApp. I'm told that Amazon is the primary motivator for the ONDC and it's not good for small retailers, and there needs to be the ability for the government to provide a technical solution for small retailers, in as much that a company like Amazon can't deboard them completely or restrain their profits, etc., throttle. These are the kind of arguments I hear, and I sometimes suspect they have popular support. What would be a reasoned response to it?
Let 1,000 flowers bloom. Let there be competition. Let the best system win. Why is public policy being used to favor one type of network versus another? As a user, do I care? If my credit card gives me points, I might not use UPI. But if my public policy is designed so that the credit card provider is not allowed to issue cards, which is what happened with MasterCard, Diner, American Express, because they didn't localize data, then you're basically favoring one versus the other. If you have tokenization and you have, there are multiple policy changes that have come in from the Reserve Bank of India, which preference UPI over other platforms. My broad point is there needs to be competition. If there's one NPCI, and NPCI is a private company, ONDC is a private company, they're owned by multiple banks in both cases. These are all private entities. Why is public policy favoring one private entity versus another? Let there be multiple versions of UPI from multiple NPCIs. Let there be multiple ONDCs. Let competition and consumers decide what's best for them. And in that, when you look at it from a nationalistic perspective, for us the battle, and Apar, we were all together in that battle for net neutrality. It was not just against Facebook, it was also against telecom operators taking control of the internet. It was for making sure that the internet in India remains as open, as public access, as accessible as we had when we were growing up. And I don't see, I want the internet to remain that way. That's where I'm coming from. I want a data protection bill that protects my data, but also protects me from surveillance from the government and doesn't give a free run to them, because that's what the fundamental right to privacy judgment was supposed to provide us, right? So I'm saying just we are seeing more and more centralization, which means that we will see more and more control being exerted over data, over speech, over commerce, over health, over education, through the centralization of platforms that are coming into play. And that's a very dangerous path that we're going down, because that's exactly how China does it. China creates regulations for private entities that it's almost like delegated legislation. It legislates centralized entities that then legislate citizens. And we're seeing those structures come up bit by bit right now. That's the way I see it.
Rama, I'll continue pushing back against what Nikhil is saying, because I have my clear biases in favor of a certain view. So continuing with that, the argument is that large firms or certain dominant players have a disproportionate gatekeeping power on the basis of personal data that they have. Now, here the reasonable response to that is bring in a data protection law. But a data protection law, it is argued, does not liberate, I'm using a word which I've read somewhere, liberate the locked user data with a large firm or a big tech player. And hence you need to anonymize that data, turn it into a non-personal data framework, and then share it for the benefit of startups by itself. Now, this was also a development of non-personal data which happened in the Personal Data Protection Bill during the JPC process, where we dropped personal data protection and turned it into data protection by itself, and there was a regulation of non-personal data. This met with some criticism by industry as well, and I'm curious, what are your views about non-personal data and its regulation, its potential for economic growth, as well as the gatekeeper argument in itself?
So my argument first on the gatekeeper thing is, there are many entities which have disproportionate access to personal data. Yeah, I mean, while I think we turn our, there's a lot of attention to the big tech companies or the large platform companies and the tech industry. There's also, let's look at a small hospital in one state versus an AIIMS, right? AIIMS has a lot of personal data, a lot of health and sensitive data. Or you look at a mid-sized bank versus India's largest public sector bank. So there is disproportionate access to resources, and now that we are talking about data, happens across different entities. It so happens that some entities may be global tech companies and some entities may be very large public organizations. So that way it is there across all entities. That's one point I would like to make. The non-personal data and some governance and some regulation around that, I think maybe it's equally important, because but whether you want to mix it up with a personal data protection bill or a privacy legislation, where already he talked about from 2007, 2011, and now most importantly from 2017, when the Justice Sri Krishna Committee, lot of deliberations and discussions have happened. Whereas now when the 2021 version of the bill got tabled, the title of the bill got changed, and even in the previous version that any data fiduciary or the data processor should share the data. So there were lots of bits and pieces. So we don't know where, what is it leading to, and what is the real purpose of those small changes that got made. So what I would say is there is a lot of attention to governance around non-personal data. It's not just data. Worldwide regulators are talking about algorithmic accuracy, right? Looking at some governance around algorithms where the maximum amount of AI is used on data, right? Similarly, we are talking about privacy impact assessment. In the US, FTC is now talking about algorithmic impact assessment. So there is attention to non-personal data, and it's some governance around it, opening up data for public good or for social good. Even a central bank in UK has come up with where data is being banks are being mandated to put data in open systems so that there can innovation happen. We need that, but should we confuse that with a comprehensive privacy legislation? I would differ on that. Non-personal data also needs some governance, some deliberations. What can be opened up? What are those checks and balances? So that while we open up data for innovation, for research, right? Healthcare institutions have always been encouraged because research has had to happen. But do we need to make that as a mandatory thing that every business is expected to open up everything? Then it's not, when you talk about non-personal data, it is not just data that is shared by the consumer or user, right? There's a lot that company is doing to build that transaction processing to be able to come out with a targeted service. So there is a business value that they're creating. So we need a lot of discussions around that. In fact, DSCI, apart from the tech industry, we have a lot of user enterprises as our members. They banks, telecom, insurance, payment companies, all of them had maximum objection to suddenly the bill having these provisions on non-personal data, because all of them use the data of their consumers for offering service, not for putting out in the public domain or unreasonable monetizing, but they cannot just share it because that's what their entire business enterprise is built on.
And non-personal data sharing, while may serve value, I think also holds a certain risk, and I've noticed that in studies which have been done on something which is called as de-anonymization, technical studies which have been done in which 4 data points through public databases have been used to cross verify and then identify the people who actually were part of those records. In fact, it may be of delight to the participants here that there are now technical studies that even the initial purchasers of crypto, of Bitcoin, have been identified, but all of the list is not public, and you can go check that up. It's not a rumor, it's actually a study. But researchers have been able to even pinpoint anonymous trades. So there's nothing called true anonymity at the same time, but there are levels to anonymity. Nikhil, before I come to you, I'd just like to now go back to the gatekeeping argument a little and bring in an international perspective a little here, given that there's so much regulatory flux in India. Especially if you look at Europe, there are advanced readings of the Digital Markets Act, Digital Service Act, which all focus on one fundamental understanding. Data protection and competition frameworks may not service or satisfy all the harms or all the regulation needed for large big tech platforms. It may need a very different kind of imagination to deal with them. So Sreenidhi, I'll just come to you that what is this gatekeeping power and how is Europe approaching it a little, given that you have clients who may also be from Europe or maybe from India entering the European market and may be concerned about what's happening there in terms of regulatory developments?
Sure. I think so. Of course, the considerations I think in Europe and India have been very different. Just when it comes to even something like data protection, I think Europe's built on 2 decades of experience with the earlier directive, and now sort of thinking around non-personal data, sharing of data altruism, also which featured in the European sort of Data Governance Act. As opposed to India, where we're still in very initial stages of even thinking around data. Of course, we've built on several years of work on the data protection front. I think where the conversation is now headed in Europe, especially with the Digital Markets Act, Digital Services Act, is this idea of looking at large platforms and the sort of thinking around ex ante regulation, which is whereas in India we think of it in terms of there are large platforms, there is and the competition regulator sort of steps in certain considerations, in certain circumstances, when you're able to establish that there is dominance of a particular enterprise in a particular market, in a relevant market, and there is abuse of that dominance, and there are some harms that accrue to the market, and that's where the governance choice at least the competition law is structured in a way that that's when you step in. Europe is now thinking around taking a step back and thinking through whether there is a requirement to step in before that sort of designation of abuse or designation of sort of even harm to the market. But I think there's still a lot more. I think even in Europe, this is something which is somewhat of an open conversation on whether we've reached a stage where we simply, in India as well, whether we've reached a stage whether the market is mature enough to adopt some of these principles directly, to import some of these principles directly. I think we've all sort of discussed that we don't have even a data protection law in place here, and also the question on whether, I think on NPD as well, the question on whether you could really equate data with market power. Whether data is necessarily a constituent of market power. I think Rama also brought up the fact that, well, data is available in abundance, and access to data by itself, access to data simpliciter, does it confer market power on any particular enterprise or any particular entity, or is it what you do with that data subsequently? And I think all of these are still very much open-ended. The conversation around non-personal data governance, boosting data sharing, is all sort of ties into this thread of, I mean, it's all essentially a governance choice. Whether you tie in all of these different legislations in within one framework, or you think of these in separate sort of threads. Yeah, I'll pause there. I don't know if I answered your question very
No, not at all. And one thing I'm curious about, Sreenidhi, given that we don't have a data protection law, sometimes I would imagine that specific regulators in specific sectors like banking, health, maybe stepping in a bit. What's been your experience? Because I don't think that there's a complete lack of protection. It's just that we don't have institutional processes for remedy, for complaint. So it's lacking, but it's not completely absent. Am I correct in my own experience, right?
Absolutely. I think, well, in an ideal scenario, you would have baseline data protection principles that apply across the board, and sectoral regulators like the RBI, SEBI, IRDAI would then build on those baselines and develop something which is specific to their regulated entities. But in the absence of those baseline principles, we've increasingly seen sectoral regulators step in, particularly the RBI. I think we spoke a little bit about data localization and RBI's diktat 3 years back that all payments businesses must necessarily store data, payments data within servers in India. More recently, and RBI has been flexing its muscles when it comes to data.
Plus, you can't export them, I think so.
Sorry?
The data has to, it's a hard localization.
It's a hard localization. Even if you process data in foreign servers, you must bring it back within 24 hours and delete it from those foreign servers when it comes to purely domestic transactions. Besides just local storage of data, recently the RBI came out with digital lending guidelines with a heavy emphasis on data and fairly, I would say, prescriptive sort of requirements around what kind of data can lending or tech service providers that service, that work with banks and NBFCs, whether they can access phone book, whether they can access contacts, whether they can access, camera permission. So really kind of going way beyond what even something like the PDP would have prescribed, because PDP would have stopped at saying abide by purpose limitation, which is you determine what is the purpose for which you need data. And you make that assessment whether it's necessary or not. But the RBI seems to have gone, slightly ahead with its thinking around what is that data that you might necessarily need to use. So I think we've sort of gone beyond that, idea of we're not operating in a vacuum for sure. There are sectoral regulators. We see the NHA also in its health data management policy come up with data localization requirements, and beyond that also mirroring some of the principles that the PDP bill had put in. So we're definitely seeing a lot more sectoral interest in this space.
Thanks, Sreenidhi. I can imagine it's quite busy. And I think one one theme which is somewhat emerging also is the high amount of international activity and coalitions which are building around data as well, and what's India's response to it. And here, Mansi, your recent op-ed in the Indian Express is quite optimistic in keeping with the line of your work, and I think it's important to be optimistic. In fact, I'm quite optimistic. I keep smiling all through all the draft proposal and tech policy developments in India. But it does become your op-ed does begin with a fairly concerning note of caution. It states in 2019, Kashmir Hill, a journalist, wrote about her experiment cutting out the big five tech giants, explained her challenges of not knowing how to get in touch with people without the tech giants, and in the following weeks of not being able to find easy digital replacements for sending huge files on the internet, searching the web, using maps, video calling, without trespassing on the territory of the big five. And this is also the sentiment or deplatforming, right? What happens if Google or a Meta decides you're not part or participant, or your geography is not participant of it? And here Mansi says that the internet is splintering and digital sovereignty is now commonplace, yet there is no better time for countries to come together and build a framework for global digital governance. Mansi, what can you expand on this a bit more? Because it seems like a very good idea, given if we need to preserve common values around the internet and make like national departures also, as has been done through international treaty making, it's been possible. So I'm just curious, I'd like to hear more about this.
Thank you, Apar. Well, I've also got a lot of flack for this article. They're like, you've written this at a time when there is an absolute breakdown of global governance. The WTO is not working. The UN Secretary General is saying that we're in a hopeless situation. And you've written an article saying that there should be coordinated global response to big tech. So I think, but my response to that was, and I thought a lot about this because I was just looking at the patterns of regulations, and it was also inspired by conversations we were having with ONDC, with the Ayushman Bharat guys, with NPCI, and I was trying to find out what they're doing on their governance side, because everything else seems going great, in terms of volumes and the people they have and how many people now have IDs and so all of that. But what are you doing on governance? Because that's like the biggest point of concern. And almost everywhere I heard GDPR. And then later when we were doing some work on antitrust and trying to look at, how are different countries thinking about it, and everyone does sort of come back to either the Digital Markets Act or the need, for introducing ex-ante regulation, what Sreenidhi spoke about, is also something that I think requires due consideration in India. And for many, many other things, the tax thing was an eye-opener in terms of how complex it was, and we were really able to get somewhere in terms of an agreement. So I saw a lot of hope there, and in not in terms of having something very comprehensive, very ambitious, but a common minimum program, like a baseline acceptance of certain regulations, like we will not allow this or we will allow this when it comes to the big tech. It's still not going to be easy. We know that in the G20, India's walked out of the Osaka track. We didn't sign the data free flow with trust, and probably today we're going to do the same thing. Is because of the Indian sentiment around data localization. But the only reason I feel like the government in India should still think about it is because this is probably the weakest aspect of our digital economy today. We, like everyone's been saying, we don't even have a privacy regulation. We are so deeply entrenched in the digital economy and we don't have a privacy regulation. It's shocking. So the quickest way for us to solve this complex problem will be to adopt something that is globally available in a baseline method, and then contextualize it to something that we want for our country. And it's true. So our Competition Act is not quite up to the mark when it comes to responding to the digital economy. Privacy is absent, and several other things. Misinformation, we've left it to the private sector, or do some things to the intermediary guidelines. I'm not a lawyer, but I'm just trying to give some examples of where I feel that the lack of a governance framework can be quickly be filled up by adopting some global principles. I mean, we are doing it anyway, right? When we are writing all our recommendations, we're like, oh, we looking at the telecom, the consultation or the draft bill that has, and there also they say US, UK, Australia. So that's exactly what everyone is doing, and these are the G20 countries. So why can't we just talk about it more formally and more productively and come up with something that's common and minimum? So that's the inspiration of the article. Even with this, I'm not confident, and I hear when people say that you're being so ambitious about the digital economy when trade, climate, the better established global governance frameworks and cooperations are literally saying no progress. But it's always a good idea to write something and put it out there for people to think about.
Mansi, I'm sorry if I put you on a defensive spot.
No,
It's
no,
not
not
my
at all.
intent at
No,
all.
no, not
in
at
fact, in fact, I think this is the issue is of expectation and ideal matching reality sometimes. I think it's not like an imprudent policy proposal by itself. It's just that how far we are in a cynical world today, maybe. And what can be more cynical than what our social media has impacted us, right, Ambar? And you've written an entire book on it. It's called The Network Public, How Social Media is Changing Democracy by Rupa Publications in 2019. So looking forward to an updated edition in 2024. But before that, we hear this word so often, surveillance capitalism, right? And what does it mean in terms of data collection, profiling, and its political impact? Because that's a large conversation as well. And what were your, eventually, for those who didn't read the book, but do need to purchase it, what did you think that is the underlying economic model of data collection without a privacy law contributing to this kind of harm, which is political behavioral manipulation?
I think Nikhil touched on that a little bit right at the beginning, and I think I also want to sort of maybe relate that to the earlier discussion that you were having with Nikhil and Rama about digital public goods and the kind of inequities that exist in the data economy, right? So we live in the data economy, and that data economy has inherent inequities. What are those inequities? There is obviously inequity of power between citizen and state. There are inequities between users and data controllers, where one has to sign non-negotiable, one-ended agreements, where we basically give data controllers ownership over our data day in, day out. There are inequities that people talk about more and more between small tech and big tech, and then obviously part of this whole data localization within this sort of broader narrative of digital colonialism, which I personally find suspicious. There is this whole domestic and foreign companies and the inherent inequities at play there. So I think the question there is also, what are the problems that you want to solve with a data protection law, right? So definitely you want to solve, through the constitutional right and a privacy law, you want to address the inequity between citizen and state. It makes sense that the primary objective of the law would be to address the inequity between users and their data controllers. To some extent, there are legislations which have tried to bring in some aspects of competition law. So something like data portability allows a competitive, or at least it facilitates some form of a competitive environment. But there also, it goes back to how it can protect your privacy, right? It goes back in terms of providing a user more options and being able to choose from an array of service providers who are out there. So so I think there, in terms of objectives or the kind of inequities that a data protection law can solve, for me it is the first two that it should be looking at, and there are other objectives where, again, at least in an indirect way, if you can solve the first two, then those are things that you should be looking at. The sort of earlier discussion also that you're having about digital public goods, I'll try to relate that. And Nikhil spoke about the open internet and sort of how we look at the ways in which that gets more and more dismantled, and why that's a problem. I'd like to sort of frame that in a different way. When we're talking about specific versions of digital public goods emerging, the question that it's a political question, or a policy question more so, that I would ask is, what is the appropriate level at which you want government intervention? So we have the stack model, kind of being adopted willy-nilly across different sectors and being endorsed or blessed in some form by the government. And I think it's a bad idea for the government to actually, push the needle in one particular direction. And I think I'll echo what Nikhil said earlier in terms of why can't there why should one particular set of entities or corporations control that? Why can't we have multiple iterations of it? And also, why is this particular vision of where the sort of all information technology development in the country, why does it need to go in that particular direction? And is it appropriate for the state to really kind of put its weight on the needle there? So in terms of the broader kind of problems that we have with regard to manipulation and everything, which is largely what I tried to cover in my book, the fact that the data economy exists in this particular way is at the root of that problem, right? So because we don't have we don't have a data protection law of any kind, which means that, and I look in a lot of detail at political targeting, but there are manipulation in all possible ways that happens using one's data, right? So the fact that your electoral data, at constituency level, at various levels, can be accessed by all kind of actors, and what we see emerging in India is a fairly sophisticated political campaigning ecosystem also emerging, where which is less dependent on sort of using social media, or at least the big tech companies like Facebook and Google, but also I would say sophisticated in slightly different way in terms of actually a lot of on-ground insights feeding into that sort of targeting strategy as well. So the first, and that problem exists at multiple levels. The first level is about access to data, and that needs to be addressed by a data protection law. Right, so our election management regulations don't really address it in any significant way. So that, I think, the first level at which you'll have to come at it will have to be through a data protection law. I think beyond that also there are, like I said, the data economy is structured in such a way that you don't have negotiating power. It's very difficult to legislate that negotiating power, around that negotiating power, and put that in place. We've had lots of ideas and lots of experiments run in different parts of the world. People have tried to kind of build on the commons idea and have some kind of privacy commons sort of model in a few places that can allow better. I think earlier we also spoke about the idea of privacy as a competitive advantage, and that will happen more. To be fair, when Facebook arrived, it used privacy as a competitive advantage. It was the first social media platform to have a privacy policy. So it positioned itself as better at keeping your data than Orkut or MySpace, right? So that will play a part more and more. I think Mansi touched upon a very good point about competition regulators looking at data as sort of market power, and those could also play a role. But I think the fundamental first line of defense is to restrict access to that data.
Thanks, Amber. I'm conscious we are keeping, we are running close to time, and just some final responses, and I'll request in sum total for all panelists to take 5 minutes so I can take 1 or 2 questions if there's any interest. Please, Nikhil, if you...
So there are a bunch of things that were said that I wanted to respond to. When it comes to non-personal data, the question really is about whose data is it? Does it belong to the user? Does it belong to the company? And for me, it's intellectual property. if there is analytics that I have developed on the basis of consumers' usage of my information, of my service, and that's non-personal data, then if for example you know what doesn't work for my business and what works for my business, because there's data linked to everything that happens on it, then I can build a competing product on that basis, and I know, and I will do that without the costs incurred in knowing what doesn't work, right? So I think from a competition perspective, we'll actually be harming businesses and harming innovation if people aren't able to get value from what they have built. So when we look at non-personal data, I think when the first version of the non-personal data report came out, I called it the nationalization of data, because it would allow a government authority to take data from one company and give it to another. And I feel somewhere that the sentiment remains the same, even though the letter of what is being attempted keeps changing with different iterations and different conversations. We need to let go of that sentiment, because effectively it's going to harm the India's competitiveness when it comes to building digital products. In terms of the NBFC regulations that Sreenidhi spoke about, I think it's the RBI has done a decent job in terms of trying to restrict access to phone books and cameras and photos, because many of these lending agencies were using that information to try and blackmail people into or even calling up their contacts and telling them that this person whose contact your book you're in has not paid the loan. There were malpractices going on, and I think that's one of the things that needs to be clamped down on. So quite welcome that portion. On one part that I noticed with Indian laws and the way we look at global lawmaking is that we tend to take EU laws and make them worse. We take different clauses we've taken different clauses from the Digital Services Act and made terrible IT rules. I believe the Digital India Act is going to be some version of the Digital Markets Act in the EU, and I shudder to think what they might do there. But I think it all boils down to giving users choice and creating an environment where there's greater competition. And regulating big tech, I think, is becoming essential to ensure that there isn't abuse of market power. Whether data is the path to take to address the dominance of big tech is something I'm still a little unsure of. There need to be other mechanisms because the internet naturally tends towards monopolies or oligopolies. You had a situation where you tried to address the monopoly or the duopoly of MasterCard and Visa by introducing UPI, and now you're trying to regulate UPI to restrict the dominance of Google Pay, Phone Pay, and Paytm. So effectively, if you're not going to let winners in markets actually win, when there is perhaps no abuse of that dominance, then those markets will fail. So I'm a bit concerned about this approach that's being taken to use data to address dominance and to take oligopolies or duopolies in markets and try to create monopolies, because eventually you will have a similar situation emerging no matter what you do.
Rama, turning to you quickly.
Quite an optimist in the way finally regulations will be industry friendly in India. But even if there is an absence of a data protection bill, as we engage with industry members, we believe that all of them are gearing up, because the basic fundamental principles of data protection, privacy, is known at least to all the mature enterprises. They've been gearing up for 2019, they're gearing up when they saw the 2022 version. So I don't think businesses are going back or slowing down on their privacy readiness. I would urge our viewers to look up some of the new ESG annual reports that large enterprises are publishing. We are seeing that in US, we are seeing that in EU. All of them are putting privacy, ethics and trust very strongly in their governance and social pillar, that environmental social governance. So that also gives me a lot of hope that they're putting privacy as a differentiator for the business, and consumers will be trusting them as in when the whole world is digitized and everything is being offered digitally. Consumers will have to, place that trust, and the businesses will be forced to work in a trustworthy way. My concern would be is the government also scaling up on their privacy readiness, because we have local, state and central and large public sector hospitals, government. I think we need to invest in their privacy capability.
Sreenidhi, please.
I absolutely echo Rama's optimism. I think in the past couple of years, we've also increasingly seen even smaller businesses, startups, increasingly think about privacy conscious products, particularly those that want to tap into global markets and service customers from Europe or from other regions. So and besides that as well. In fact, I also think principles like purpose limitation and mapping out what data you actually need, what you don't need, is helpful for businesses to minimize, say, breach exposure. Like, why hold on to data that is out there for someone to hack into when you don't really need it? And that's some thinking that we're seeing increasingly among businesses. So I'd also kind of share Rama and Mansi's optimism here. And I think amidst all of these, I think we talked about the Digital India Act, the telecom law, non-personal data, but I'd be really hopeful to first see a data protection law, which kind of starts with the basics. When I think just three sort of takeaways there, focusing on personal data protection, tying it back to what the original idea was of allowing an individual control over her personal information, limiting it to that objective, and working on making that a robust legal framework, keeping that law very principle based, not unduly burdensome also for businesses, and sort of focusing on building a robust regulator that can work with industries. And I think that's a great also takeaway from global markets like the GDPR, where we've seen capacity constraints among all DPAs, all different regulators. There were so many things that had to be built out there, codes of practice, codes of conduct, certification schemes, which haven't really happened even now. So I think just focusing on strengthening the capacity of the regulator and helping and creating it in a way that it can work with industry in creating a robust law. So I'll end on that note.
Mansi, please.
I'll be really quick. So there are just two things that I want to say. One is that I think it helps to see policies on digital economy, to see them in the context of the overall economic policy making that is happening in the government. It reflects their philosophy, their economic philosophy, right? When you see Atmanirbharta everywhere, wherever you go, you'll see Atmanirbhar, Make in India. So some of the choices that the government is making in terms of its techno-economic or economic regulation seem very obvious in that sense. But what I have also observed, that if you have taken, or if and when the government has seen evidence of where their policies are failing, they have had the courage to change. Even this government, they've had the courage to change or to rethink. And I can say that in terms of the policies related to import tariffs, or the policies that they now have on stepping down on the value addition. So if you're able to, so I remember when the whole crypto ban thing happened, and there was a lot of noise from companies that started moving to the UAE, and they said that these companies are very mobile, we don't care, your regulations don't support us, we are doing really well, it's fairly borderless, the business model, so we'll just go to the, and that at least got them to start thinking about crypto regulation. Like, sure, we're not going to ban, we'll think about how to regulate. And that's a movement. So policy making is slow. You have to deal with the economic philosophy of a reigning government. Every government comes with its own. We've been used to a different type of philosophy of liberalism and openness, and now we're in a, at least for someone like me, I've always just believed that everything needs to be open, and that now you're being shifted towards that world that is largely deglobalized and everyone's inward looking. So it's hard to readjust to that, but I think with patience we'll be able to do something. It's not so bad.
And a cultivated sense of patience.
Yeah.
Ambar, any final comments, please?
Yeah, I'll try to end on a more optimistic note than my general theme through this evening. I think the main sort of advantage that we have of being so very late to the party is that we can learn from what has happened in the last, let's say, 30 years of not just having data protection laws, but also the successes and failures of enforcement strategies in different countries. So hopefully, as we work towards the new version of a data protection bill, we can try to, like everybody said, try to sort of have those first principles in place, but also have strategies in place for the data protection regulator to actually, because it's going to be a very, very, very wide mandate, and give them the tools and the wherewithal to actually enforce the law.
So before we close, given the patience of some of the attendees here, I'll permit 2 questions and about 5 minutes of discussion. You may direct it to any person in specific. And so there are 3 questions. Please keep them short. We'll take them at a go. And please direct them to a specific panelist if that is what you want. Please, go ahead.
Right, it was a very fascinating discussion. Especially I saw this particular dissension about the 2 ways in which we think of data, often about a resource and a personal right that inheres in a person. And I saw this in the panel as well. And I wanted to direct this question on a particular theme that comes up, which is in relation with the current proposals about a data protection law, the proposals that have come so far. Now, Mr. Sinha, I remember that you mentioned it at one point about the title of the report and generally this sense about the framing of this data protection proposals as one that also indicated data as a resource, as an objective. Even the title, simply using the term as digital economy being somehow problematic. But when we go down to the actual terms of the law itself, one finds that the grounds for processing data miss 2 very prominent grounds. Reasonable purposes, legitimate purposes is reduced, diminished into something for reasonable purposes, which is not at the control of a private party, and contractual necessity is eliminated entirely, which suggests perhaps that private parties and extractive policies of private companies are significantly limited in these data protection proposals, which is somewhat contrary to the suggestion that has been made that comes supposedly out of the title of the bill. One could then perhaps say that the digital economy problem comes more, as Mr. Pahwa has been saying, in relation with the government using data resources. Would you suggest perhaps that that's how we need to reconsider it, that extractive policies by private companies have been restricted considerably by this, but the government has been given too much power? And this would also go to Mr. Pahwa. Would you suggest that private companies have been restricted too much in the data protection proposals? And then to both of you perhaps, whether the government has been given too much power in the data protection law to use data as an economic resource?
So I'll take this question with the other 2, just in interest of time and not to keep the staff back. Sir, you had raised your hand.
Thank you. It was fascinating in some ways, coming from a different context. I'm trying to raise questions in the context of what are the future trends. We're not making laws for the today based on the experiences of yesterday. We are making laws of today on the likely trends which might come in the space of data development. And to my understanding, limited as it is the question of data connected workers of the future. And the understanding is that for last 15-16 years, data or digitally connected worker is going to be seen increasingly in perhaps all sectors of the economy. To that extent, whether it is in financial, medical, tourism, manufacturing, infrastructure, just about everything. So those technology trends are likely to develop faster than the trends of the past. And that is why I want to sort of look at the past, how the technology has evolved, and we are tending to conceptualize our discussion in the experiences of last 10-15 years. So I would like to get some views on the trends of digitally connected workspace of maybe 2030s or 2040s, which you'll be sort of looking at. And my understanding is that the nature of technology and the change it brings in is always faster than the previous experience. Thank you.
Thank you. That's a standard tech policy question, but it always leads to very different responses. I'll take one more question and then I'll throw it back to the panel.
Thank you for a wonderful evening. My question is on the theme of whether there can exist two competing interests in the data protection, that is data protection itself and economic growth. And as Sreenidhi mentioned, that RBI itself has been going into details that whether lending apps can define what data sets can be acquired from the phone, what cannot be, and I see the reasons why it should go into those details. And Mansi then mentioned that the space is now horizontal and there's intersectionality, everyone is having a stake in this. And with this I see if the DPA is an umbrella central authority and all these sectoral regulators should have the power, and here whether certain sectoral regulators should be allowed to think more in terms of security and others more in terms of economic growth as well, if those two competing interests are permitted in this upcoming legislation.
And would you like to direct it to someone here?
Both Sreenidhi from a perspective of having a global understanding and Mansi.
So let's start with that.
Okay. So like I said right in the beginning, I don't think they're always conflicting. It's possible for them to coexist. If you have right governance frameworks, it's not an impossibility. Like, it's not as if companies in Europe are not using data, right? Or they're not being able to. They have the GDPR with whatever limitations it has, and a lot of criticism that has come its way in the last few years. But it's not as if a privacy bill or privacy protection would mean that it would necessarily conflict with the economic growth. So I feel like, in fact, if it is viewed simultaneously, your governance frameworks will be stronger and more productive. So I don't necessarily see a conflict. Operationalizing it might be, sure. Like, you want to know exactly how you will allow data portability, how exactly would you want data to flow from one party to another, but does not say that don't let data flow. So if you're able to see it together, I feel like the solutions are likely to be better.
Yeah, and on your question around just sectoral regulators and their interplay with the DPA, I think the PDP bill also proposes some kind of a collaborative, consultative mechanism where, again, I think what the sectoral regulators could do is identify those different categories or classes, again, of principles. Like, I'm also not sure if sectoral regulators should also be going into that level of granularity, like the RBI may have done on what specific permissions can you access. But I think they can identify the problems a lot more closely, very specific. So to sort, like lending agents, what are the kinds of specific challenges that might come about if lending service providers, tech service providers are given access to this data. So perhaps those principles can be a little more specific and tailored. And I also think there's a great potential to maybe use self-regulatory organizations, the SRO frameworks. That was something that was contemplated for the payments businesses, but we haven't really seen that happen. I'd envisage a world in which an SRO for payments could even work closely with, say, the DPA, bringing both that mixture of specific data, consent, knowledge, expertise, and marrying that with like industry requirements and industry objectives.
Rama, would you like to take up that question about the exponential gap, as Aziz Wazir puts it, between technology development and legislative deliberation, and whether we should be almost as quick as technology forms to make laws also? I think about it from both sides, right? The positives and the negatives. So the absence of law is the absence of certainty, or policy is absence of certainty, and this gap always exists. How do you look towards the future and make a law when you can't see it clearly. I think that if
Yeah, I
that
mean,
paraphrases it.
Sir was talking about having some, clarity even for 2040, 2030. That's what Sir was saying. I think particularly the way digital technologies are evolving, I think regulation will always lag the technology development or innovation. I think that's what the last few years have clearly demonstrated, and in the future, because every regulator is responding to the technological evolutions that are happening and getting a sense of that. Even when you look at something like cloud, right? A lot of governments started looking at cloud 7-8 years back, and slowly some kind of regulations or things are coming up. So even now we can't say that there is so much clarity in every country on what to do with cloud and what not to do with cloud, and how do you regulate a cloud operator, right? So I would say that in the digital technology space, regulation will always lag the technology developments that are happening. And once a particular technology hits the market, there is wide acceptance and wide consumption of that, then a lot of issues will come, competition issues will come, privacy issues will come, and a regulator will respond to that. I think that's what we are seeing, and in the future also, in the near term also, I would say that would be the way it will happen.
So there's some interest from Mansi and Nikhil to also contribute in response, and just like to request to keep it brief.
Just 2 seconds. I just wanted to say that since you asked about workers, right? So in terms of the labor market, I think thinking of the future means more on the policy side, and I think where that requires work is definitely occupational mapping and skilling. That's where it's going to be a transformation of the labor markets as we're seeing going forward. And the best way to prepare ourselves for that would be to see what are going to be the new types of occupations that will emerge. So when you think of innovative jobs, now you only don't think of the IT industry, you also think of textiles, where a lot of designing is happening through the use of technology. You see 3D printing. So if you're going to narrow ourselves to just thinking about the digital economy, I think, and I'm saying this again, sorry, that I think we have to view it as more horizontal, and therefore all policies that we look at need to be in from that lens.
There's a paper they've done some work on this.
Very quickly, I don't think we should rush to regulate the future. Regulation always restricts activities, which restricts exploration and innovation, and restricts the ability to create something new. And regulators will always be outdated when it comes to technology, and I hope it remains that way, and people are able to build things without being told what they can build and what they can't build. When there is harm or potential for harm, obviously we need to have laws that ensure that there's no harm that comes to people. But on the whole, not just in tech, what's the need to regulate everything? I mean, some space for individual innovation needs to be there, no?
So I come to the first question, and that's posed both to Amber as well as to Nikhil, and I hope you heard it clearly. But just to phrase it just for convenience as well, and I hope I do justice to it, is that the titling of the Sri Krishna draft report and the draft bill by itself actually is not the substantive meat of the proposal, which in fact does provide for co-protections that are in favor of individual privacy and may not actually be a complete unregulated sphere of private power, commercial power by itself. So Amber and then Nikhil, please.
Yeah, I mean, I'll try to clarify what I meant in a little bit more detail. I think my primary reservation with the 2018 draft, at one level, when I spoke about not so much the title, but with regard to the primary objectives that were identified in that report, was that it is quite unusual to see a privacy legislation identifying what is a competing policy objective, almost hand in hand with the need to protect privacy, and that I actually agree with you. I don't think that reflects as much in the text of that 2018 draft as much, but I think it is still quite problematic because when you kind of deal with statutory interpretation later, the sort of objectives that you identify both in the draft as well as in the accompanying report are some of the things that you go back to. So when there are kind of gaps in terms of interpretation, I do think that is problematic. I actually think that subsequent versions of the bill that we've seen have gotten worse in terms of taking away power from the private sector and giving it to the government. And to some extent, I think there were huge problems with the first draft also in the context of provisions. Since you mentioned grounds for processing, I think the provisions around allowing the state to circumvent consent where it deemed it necessary to provide services or to provide sort of benefits, I think those were provisions that I personally found extremely problematic. And I think in subsequent versions, both in terms of completely diluting the limited protections that we had in the 2018 draft with regard to surveillance reform, as well as other powers that were given to the state, I think that we've basically seen, and that's a trend across digital policy making that you will see, even with the intermediary guidelines. That is the trend that we see, where there is more accountability pushed on the private sector, and there is sort of more access to power that is given to the state.
Completely agree with what Amber said, and again, with respect to multiple regulations, not just what we're seeing in the data protection bill, what you're seeing is a transference of power upwards, in the sense from the private sector to the government, and the government regulating people and their activities through the private sector. You've seen this with the IT rules, you're seeing it with the data protection bill, you've seen it with the draft e-commerce regulations, multiple regulations. You're seeing the same trend emerging, and that's why I said that it's very similar to how things happen in China, because same thing, you regulate people through centralization, and essentially the companies will do what the government will have to tell them to do in that sense, because the law permits it. The other part that I wanted to also add was and correct me if I'm wrong, but the latest version of the bill also diluted purpose limitation in terms of processing of data. Sorry?
It does something strange, it's not clear what it does anymore.
I thought it diluted purpose limitation, which is a huge problem which in terms of processing of data. So it's not been good for users. So what we're seeing with multiple policies, that instead of empowering users, you're actually disempowering them by empowering the government and increasing its control over private companies. And I hope that trend ends at some point in time.
Thank you, Nikhil. And with that, I'm bringing today's evening to a close. And as much as we may not have benefited in audience numbers by itself, but I think, due to the quality of the discussion here, will benefit in posterity. Today is marking the year-long celebrations of the Diamond Jubilee of the IIC, and it will continue to be a center of internationalism, deliberation and thought. What we've witnessed here in the panel has been a diversity of viewpoints, which do in some manner justice to the diversity of issues, concerns and benefits of technology. For me personally, technology has been a space of wonder, curiosity and fulfillment. I've built my personality on the basis of the assimilation and interaction with technology, and I have no restraint in saying that, as it does for many people today. I hope it keeps doing that as a force for good, and I hope this kind of dialogue which is here also benefits online audiences. If you did watch it, please do share it, and please feel free to reach out to any of these speakers here. They engage quite publicly, and they are voices which like to engage with views which are contrary and differ from them, but also are always open and offer ear in terms of their writing and their work. Thank you so much, and good night.